thank you guys all for coming. We're going to get started. Otherwise, Jerry will launch into some sort of protest. My name's Amy Moses. I'm the Rhode Island Director here at the Conservation Law Foundation. We wanted to get together and say thank you to everybody in this room and everyone who's not in the room who worked together on this huge, long, deep, wide, crazy fight to stop an unnecessary frack gas and diesel oil power plant. So thank you, thank you, thank you. Just a couple of quick logistics. If you could turn off your cell phone ringers, there are 3 exits, no smoking, and the restrooms are outside the door to the left. The point of today is just to get together, talk, reflect on the fight and what is ahead. We wouldn't be here without all of you and many other people. You guys have all lived this, so I feel like, I'm preaching to the choir. Jerry's going to speak for a little while and cover a number of points that he's prepared, but we're going to leave most of the time open for questions. It's really been an honor and a privilege to work with so many of you. Jerry's been here since day one. I kind of came in the middle, but this was really an amazing journey for all of us. I think it's going to take a little while for it to sink in what a big deal this was. And we should definitely stop and eat cake and celebrate this victory, because there aren't very many victories in the environmental community, and there certainly aren't very many in Rhode Island. So we hope this is the first of many cakes and the first of many victories.
So yes, and if you can't hear me in the back, say something and I will try to speak up. This is not law school where sitting in the back means I won't call on you, because I will. I do have 7 points that I want to start with briefly, but as Amy said correctly, we'll leave most of the time for questions and answers, because I know folks have questions. So first point is, I agree with Amy. We are all stronger together. The local community activists in Burrillville had an absolutely crucially important role to play in this, starting with pushing the Pasco Utility District to walk away from Invenergy on the non-binding letter of intent on the use of the water from well 3A. Your doing that got us the time to get a lawsuit up and running and to get into court and do what needed to be done. And the role of the lawyers was also important. Many of you, either organizationally, like the Burrillville Land Trust, or individually, like Sister Mary Pendergast, tried to intervene. The EFSB didn't allow you to. We got in, so there was a role for the lawyers as well. And the question as to which was more important than the other is the wrong question to ask, because the answer is we're stronger together. And while we're on the subject of the role of lawyers, Burrillville was very, very, very fortunate to be represented by Mike McElroy, who is unequivocally the best, most experienced utilities lawyer in the state. Second point, we at CLF, and probably all of you as well, felt a little bit of the David-and-Goliath in this case. Invenergy told the EFSB toward the end of the case that they had spent $45 million on the litigation. That went for options on the land and engineering reports. 23 expert witnesses, 7 lawyers from 3 firms in 2 states up against poor Mike McElroy and me. So there was that David and Goliath aspect to it. Third point is, we won the battle, but we didn't win the war. And the larger issue here is climate change. And the news on climate change is really, really bad. CO2 emissions in the United States and worldwide are continuing to grow, 2.7% per annum. Use of fossil fuel, natural gas is growing in the United States and growing worldwide. Use of fossil fuel oil to produce electricity is growing worldwide. Coal is a little different story. Use of coal for electricity is down in the United States, but is up in the rest of the world, and so that's a wash. We now know that the Greenland glacier is melting much, much faster than it had been previously understood. And when that's gone, sea levels will rise about 22 feet. The West Antarctic ice shelf is melting faster than previously known. When that's gone, sea levels will go up 15 feet. 2/3 of the cities in the world with a population of 5 million or more, 2/3 of those cities will be inundated by 10 feet of sea level rise. Just from Greenland, we're looking at more than double that amount. We're living in a country where our president has withdrawn us from the Climate Accord. Throwback to an earlier era, I apologize. And in Rhode Island, we have a governor who not only supported this plant for Burrillville from beginning to end, even when it was clear that the plant was going down, we have a governor in Rhode Island who promised in the last election, in the 2018 election, promised in writing, to support a statewide climate bill with mandatory, legally enforceable carbon emission reductions. And when that bill was in the General Assembly this past session, she reneged on that promise. So yes, we've won a battle, but the war is still going on. Fourth point. There are different ways of addressing climate change, and what we've just been discussing sort of highlights two different ways. There is fighting against a fracked gas and diesel oil power plant. We won. That's really, really good. That's one way to go about it. Another way of going about it is to pass broader legislation, like in last session, the Global Warming Solutions Act, that would provide for mandatory, legally enforceable carbon emission reductions that would make it impossible to permit or cite any power plants like this in the state, this particular one, or the next one, or the next one. My purpose here is not to argue which of these two approaches is better, because we probably need both. But I do want to alert you that in the coming session of the General Assembly, that's going to start on January 2nd and run through June, there is going to be a new piece of climate legislation introduced. It may not go under the name Global Warming Solutions Act, although it may, but it's going to be a bill that, if enacted, would have mandatory, statewide, economy-wide, legally enforceable requirements for reducing carbon emissions. And we would like your help in getting that bill passed this year. I think the climate up at the State House, and I don't mean that as a double entendre, I apologize. I think the climate at the State House may have changed this year with the recent large demonstration of the Sunrise movements, the students. Sunrise is sponsoring another climate strike tomorrow. Information about that is available on their website. But just like so many of you came to every session of the EFSB on Jefferson Boulevard in Warwick, we'd like to see you with us, standing shoulder to shoulder on the climate bill that is coming up. Please join us. You know, fossil fuel, Michael Polsky, the president of Invenergy, tried to make hundreds of millions of dollars on your backs, the people of Burrillville, He's not going to have that opportunity, but there are other fossil fuel executives who very, very much would like to do the same thing. Last year, when we had a Global Warming Solutions Act, it was the American Petroleum Institute lobbyist who was up there testifying against it. So, fifth point, I think it is possible, it's not certain, but it is possible that the Invenergy case represents a turning point for all of New England. And I think it is now possible, again, not certain, but possible, that there will be no future large fossil fuel power plants permitted anywhere in New England. You know, one of our, I said earlier that Invenergy had 23 expert witnesses. We had only 3. One of our experts was Chris Sticks, who testified in the Invenergy proceeding before the Public Utilities Commission, not the EFSP proceeding, and he was testifying for us on ratepayer impacts. And some of you may remember that Chris was saying to the PUC that the Invenergy plant, even if permitted, would not be economic, would not be lucrative for the company, for Invenergy, to run, to operate, to build, that the way the energy markets in New England are going now, it is just not economically viable, it's not profitable to build large new gas-fired power plants. The PUC didn't believe Chris, and the commissioner wrote a report that said yes, it would be a good plant was needed and would be good for ratepayers, but he was wrong. And one of the ways that you can tell that Chris was right and the PUC was wrong is when you look at the proposed gas-fired power plant for Killingly, Connecticut. Unlike Invenergy, the Killingly proposed plant now has a permit from the Connecticut Siting Board. Unlike Invenergy, which lost its legal relationship with the ISO, the operator of the New England electricity grid, to sell its power into the market, the Killingly plant does have that so-called capacity supply obligation with the ISO, so Killingly will be able to sell its power into the market if it's built. And the owners of the proposed Killingly plant have been trying to get funding, loans from banks to build that plant. And so far, they've been unable to do that. And the reason that they've been unable to do that so far is that bankers are A, smart, and B, careful with their money. And they're not going to give a loan to a company that will go into bankruptcy and be unable to repay the loan. So in Killingly, you have playing out, at least so far, a sort of real-world example of what CLF's testimony, what Chris Sticks' testimony in the PUC was saying. It is no longer economically viable to be talking about building large fossil fuel power plants in New England. You may get a permit and still be unable to build that plant. I am not, by the way, I am not promising you that Killingly won't be built. But I am saying that we may be at a turning point where no new permits for large fossil fuel plants will be granted in New England. Sixth point, just say a word about the multiple problems with the Energy Facility Siting Act, the 1986 law that created the Energy Facility Siting Board that we have all been laboring with for these 4 years. Remember that the statute was written in 1986 as a way of getting plants like this permitted more easily. What the General Assembly perceived accurately back in the 80s was that local opposition to proposed power plants was making it very hard to get them sited anywhere. So let's take away from local communities the authority to grant or deny permits and put that with a central board. You remember the Superior Court water suit that CLF and Burrillville filed against Invenergy in the town of Johnston, challenging their water contract. The first week when that lawsuit was filed, we went into Judge Silverstein's chambers to talk about how the suit was going to play out. Invenergy's lawyers were there. And the first sentence out of the mouth of Invenergy's lawyer, Mark Russo, was, "Your Honor, this law was passed in order to make lawsuits by folks like CLF in Superior Court impossible." And what he was saying was true. The law was passed in order to speed up the permitting of plants like this. You already know the problem with 2 out of 3 of the statutory members of the EFSB sitting at the pleasure of the governor, and the pressure that that could put on members of an EFSB when you have a governor who's strongly supportive of a power plant. There is that whole question of local representation, if any, from a local community on the board. There is now, and some of you are aware of this, there is now an effort being coordinated by the state's Office of Energy Resources to run a stakeholder group and consider possible changes to the Energy Facility Siting Act. Paul Roselli has been attending those meetings. The town of Burrillville has been represented both by your town manager, Mike Wood, and by lawyer Leah Donaldson. There are a lot of proposals there have been efforts to weaken the Energy Facility Siting Act to make it yet easier to site power plants. We defeated those efforts in the last session of the General Assembly, but those could come back. CLF has been at the table of this stakeholder group pushing to ensure that there be a public representative on the EFSB looking after environmental issues, environmental justice issues, ratepayer interests. We've been pushing to make sure that the carbon emission reduction goals in the Resilient Rhode Island Act of 2014 that Meg helped to write and get enacted be made mandatory for the Energy Facility Siting Board to consider. I don't know what kind of bill or bills, plural, will come to the General Assembly in the coming session to revise the way the Energy Facility Siting Act works, but I'm pretty sure they're coming, and I'm pretty sure that you folks will be interested in following those bills and making sure that the Energy Facility Siting Board standards don't get further debased. It would make siting plants easier. Seventh and finally, then we'll throw this open to questions or discussion, I just want to take a moment to look at some of the different kinds of mistakes that Invenergy made through this case. Create, if you will, a taxonomy of Invenergy's multiple mistakes and errors. First, there's the calculated risk. Invenergy made a careful, conscious, deliberate, on-purpose decision to enter into a non-binding letter of intent with the Pasco Utility District for water, because Invenergy wanted it to be non-binding so that they could walk away from the deal if ever they wanted to. They didn't want a binding contract. That was a deliberate decision on their part, because it never occurred to them in a million years that community pressure would be brought to bear on the Pasco Utility District and that they would be denied water. But their mistake in going for a non-binding letter of intent was a carefully thought out decision. And then there is the category of mistakes that are a result of ignorance. For example, Invenergy honestly, genuinely didn't know that here in New England, the interconnection costs, the cost of building the transmission line from the power plant to the nearest national grid substation 8.5 miles away, falls on the developer. It's not that way all over the country. There are other ISOs in the Midwest, in California, for the Mid-Atlantic states, and different ISOs have different policies of who pays for that interconnection. And none of these ways are right or wrong, they're just different. In most of the rest of the country, in places where Invenergy has many, many, many existing power plants, the developer doesn't pay for those interconnection costs. Those are socialized and all ratepayers pay for them on the theory that the entire electricity grid is being helped or benefited by the addition of this new power plant. So they were genuinely shocked when it turned out that they were going to have $168 million in interconnection costs that they hadn't figured on. That was just ignorance on their part. Then there was another category of mistakes they made. And that category was not mere ignorance, but out-and-out stupidity. For example, Invenergy filed 2 lawsuits in Washington, D.C. with the Federal Energy Regulatory Commission, FERC, to get FERC to decide to transfer that $168 million in interconnection costs from Invenergy to ratepayers. And Invenergy didn't tell their lawyers at Adler, Pollock and Sheehan that they had filed that lawsuit. So on December 1st, 2017, when I told the EFSB, the jaws of the AP&S lawyers dropped to the ground because they hadn't been told by their client that there was a pending lawsuit at the Federal Energy Regulatory Commission that would transfer $168 million. That's just stupid. You don't tell your own lawyers what you're doing. If you rob a bank and you have a lawyer defending you, you got to be candid with your lawyer. And one of the ways I know that the AP&S lawyers their jaws all dropped when I told the board this. I was in court when it happened, but somebody just told me last week that they had reviewed the tape on Uprise RI of that day, and they saw the look on the faces of the Adler Pollock lawyers. So that's another whole sort of species of mistake that they made, that stupidity beyond ignorance. And then there's hubris, arrogance. Remember when the 2 witnesses for Invenergy and CLF were testifying back to back about this exhibit? And it came out that this was an exhibit of our witness, Scott Cummings of the Nature Conservancy. This appeared as figure 2 in his pre-file testimony. And Scott was explaining to the board how the proposed site for this power plant was a uniquely bad place to build a power plant between Maine and Washington, D.C. And it turned out that Invenergy had called the Nature Conservancy to get the underlying data for Scott's graphic. Invenergy had lied to the Nature Conservancy about what they were going to do with it. They said, we're going to do a conservation project. A conservation project. And then they had misused the data. I think by accident, so we're back to the species of stupidity. But that allowed us to put Scott Cummings on the stand to explain that this was his data that he had developed, that he had derived, and all the ways that Invenergy had inadvertently misused the data. That's just hubris. That's arrogance on their part to lie and proceed in that way. And none of those mistakes helped them. Let me end there and throw this open to questions or comments or disagreement. Paul.
I remember you doing something like this a while ago, and I took the opportunity to thank you. And I want to do it again, not on behalf of the Land Trust, not on behalf of anybody, but a heartfelt thank you for your time, your effort, your expertise. You, Amy, James, the other members of CLF, our friend who left for California, Max Green, and everybody at CLF. Thank you so much. And I do have a question. And the question is that I'm a little bit surprised at this point that, how important, I'm surprised that you didn't mention the order 140 from the FSB, and how important, how far-reaching, what significance do you feel that order has in the way it was written?
This is the order denying the permit. So the question is, what is the significance of the written order recently issued reflecting the unanimous decision, the 3-0 decision last June 20th, denying the permit? Let me say 3 things about that order. One is, when I read it, I was surprised. Some of you will remember being in this room here 6 months ago, and I said that when the order, when it came out, would be 150 or more pages, and I was wrong. So 3 things about the order. One is, it was very gratifying to see, as they proceeded through the analysis of, is the plant needed, is the electricity needed, they proceeded page by page by page, lifting the figures, facts, and statistics from CLF's brief. So that is really nice when you get a decision where you see your brief reflected in the decision. Second, I was, like you were, disappointed that the EFSB did not go on to rule on the fact that this is a uniquely bad place to put a power plant. Rhode Island has, you all know the idea, the concept of a legal precedent, that a court, once it decides one thing, that's a precedent, and they keep that rule in place unless something unusual happens, in which case a precedent can be reversed or overruled. Rhode Island, in administrative proceedings, like at the Energy Facility Siting Board, Rhode Island has a very, very strong legal idea of precedents being well looked upon. They're not absolutely binding, but they're very, very persuasive. And energy markets change so frequently that the fact that the EFSB ruled only that the plant isn't needed and not also that this is a very bad location makes it legally possible for somebody to file a new application for a new power plant in that location tomorrow or next week or next month. If the board had ruled This is a uniquely valuable piece of land between Maine and Washington, D.C. You can't build a power plant there. That would have helped us more if there were another case. That's the second thing to say. However, the third thing to say, well, I may cheat and add in a fourth. The third thing to say is, remember what I said about the Killingly plant. These plants aren't economic, and I don't expect a proposal next week or next month or next year for a new power plant in this location, because it wouldn't be economic for the company to do it. But, let's go back to what I said 20 minutes ago. We need a Global Warming Solutions Act in Rhode Island or a similar bill. We need a statute that makes economy-wide, statewide carbon emission reductions mandatory and legally enforceable, so that we are not fighting power plants individually, one by one. There will be that bill this year. Come join us and help get it enacted. Other questions? Yes.
Hi, I'm Cynthia Mulvey with the Smithfield Land Trust. And now that you are fresh from this victory, congratulations to everyone in the field, because we were rooting for you, we were worried about it, and we are still vigilant about what takes place in the state. We noticed that our majority leader in the Senate, Rubbers Ruggiero, had passed a bill this year that enables him and his direction to oversee and overcome any local zoning concerns about any developing in the state of Rhode Island. With that being said, tonight we have a hearing, if anyone is interested in attending, for the sand trace, which is putting urban density to the tune of 5 to 6 Walmart sites together in a rural spot on Nantucket, which is one of 14 federally designated waterways. We really have our work cut out for us, because this developer has finessed into master plan approval, and now we are at number 2 approval tonight. We have the ability to speak at the end of their very extensive presentations. They take forever, and then they give you 3 minutes of your time. So we are concerned because we have health, safety, and welfare concerns that go way beyond any positive considerations. And
is there
if anybody
here?
What?
Is there a question here?
The question is the Conservation Law Foundation available to address the fact that there are apparent Clean Water Act violations now taking place at this site?
This is not the forum where we would consider that, but you can contact us at the office,
Yep.
and it is something that we will look at. I'm not promising that we will take it, but this is not the forum to pitch that.
Thank you.
Other questions? Rich?
Well, I did want to mention that in addition to the people that you thank for all the help and support that you got, certainly the environmental organizations in Rhode Island, ECRI, Audubon, Nature Conservancy, Save the Bay, they were key in backing the opposition. And just as important as these environmental organizations in backing the oppositions was the coverage that we got from Steve Alquist and Eco Rhode Island, Tim Faulkner, and Frank Carini. They deserve as much credit. Thank you very much. We couldn't do it without you.
No problem.
Yes, sir.
What's the status of the ownership of that piece of property now?
Insofar as I know, Spectra still owns that land. It will, absent some approval to do something else with it, it is likely to stay in its current position, current status for some time. Remember Invenergy's argument at the EFSB saying, this is private property, and generally people are allowed to do what they want with private property. as a matter of law, that's a pretty accurate statement, and that land is still owned by Spectra and is still private property. Yes?
You made a superb point, giving credit to all of the environmental organizations in Rhode Island. Why don't they act in concert to create a legislative agenda for the coming year?
Do you want to take that, Amy, or Meg?
Sure. We are trying, and we do work together. The Environment Council of Rhode Island is sort of an umbrella organization for all of the environmental groups in Rhode Island, and that has various subcommittees, and many of the environmental groups have been meeting regularly while the legislature is not in session to craft what we're going to be doing this session and working together. But we can't put in bills. We're not legislators. So we need to find environmental champions who are willing to put their political muscle behind these bills. And there are a lot of strategic considerations that go into who's going to sponsor what other bills are they pushing, what other issues are happening at the State House. So we are absolutely 100% making great efforts to work together. Some groups have slightly different areas of expertise, for example, and have somewhat different priorities. And it's important that we have a big tent and that we have a lot of different people working on a lot of different issues. So there is some diversity in terms of the initiatives that we're pushing forward. But through the Environment Council, we are all coordinated, collaborating, communicating, and we are really trying to get everyone to come together this year. It's going to be the 50th anniversary of Earth Day. And focus on a climate bill and make that be the key top legislative priority for the environmental community. But we can't do that without all of you showing up at the State House, sending emails, and contacting your legislators, and contacting the governor as well. So we really would encourage everyone to get involved with local land trust groups, environmental groups. You can be an individual member of the Environment Council. It is really an all hands on deck emergency. Jerry gave some really gloom and doom statistics about climate that we are facing here in Rhode Island with our 400 miles of coastline. We're really on the front lines of the climate crisis. So we as organizations are all trying to work together and make this our top priority, and we'd love it to have all of you join us.
And let me add one thing to what Amy said, all of which is true. Meg Kerr here is the immediate past president of the Environment Council of Rhode Island, and I was her predecessor as the Environment Council president. ECRI, the Environment Council of Rhode Island, represents all 60-plus small, medium, and large environmental groups in the state. And it has been my observation that environmental groups in Rhode Island, small, medium, and large, work and play together very, very well and cooperatively. And the climate bill that emerges in this session of the General Assembly will be the result of close, long-term collaboration by multiple environmental groups to get that bill right and to learn from our failure from the last session and the previous session. That doesn't mean we're going to succeed this year, but the cooperation between environmental groups in Rhode Island is really good and encouraging.
Well, I just want to say that we belong to a political action group. We have representatives who have visited us and made themselves available for suggestions for legislature, for legislation that they could get behind. I contacted several of the groups that you've been mentioned, and I got kind of evasive sidestep answers. We wanted to give a list to our representative, our local rep, and I couldn't get anyone to give me a coherent reply. It seemed to be a lack of coordination.
Well, ECRI has every year a list of priorities of bills in the State House that we're working on. It's always on one piece of paper, two sides. There are bills that we're supporting that are good bills, bad bills that we're opposing. Any individual or organization can get or pitch to ECRI, propose to ECRI to get a bill on that list. This is a bill we're supporting, it's a good bill. This is a bill we're opposing, it's a bad bill. Meg, you were...
Well, I just wanted to add to it that January 15th at 3 p.m. at the State House, ECRI's having its coffee hour, and the emerging priorities will be presented at that time. I think perhaps one of the problems you might have run up against is that a lot of groups don't have a firm list of what they're going to be working on until the session really gets going. I mean, their internal conversations, the board is talking, they don't have a list maybe that they can share with the public. But by January 15th at 3 o'clock, there'll be at least an initial list of the priorities for the Environment Council. And it's open, come.
Well, definitely will. If I can't come, someone from the group will come.
Great.
I mean, do you have any idea of the impact in the press if there was a stronger, more vocal, more visible?
We are working on it. We've been,
Well, but it's not visible. I feel that I'm relatively informed, and yet today is the first time I had an understanding that there was such a thing as the coalition. If 78% of the Rhode Islanders vote for the 2018 Green Bond, where are the people
Come
who...
help us. Come help us fix that problem. We tried. We worked very hard at that.
Let's move
Yeah.
on to additional
Yeah.
questions.
You talked about Invenergy spent $50-something million, doing this case.
45.
$45 million. But they also clawed back somehow $27 million from the energy markets at the same time, which I don't know if everybody appreciates. So they got a half-off deal. Really.
So let's talk about that. You'll notice in my prepared remarks, I tried to keep the energy market obscure terms and acronyms out, but now we're going to tread in them. And there was incidentally a very, very clearly written, easy to understand piece about this recently on Uprise RI. So here's what Steve is asking about. Invenergy spent $45 million on this case from the beginning to the end. And during the course of the case, they didn't have a power plant, they didn't have a permit to build a power plant, they will never have a power plant, and they'll never produce 1 electron of electricity. And yet, Invenergy got $27.9 million from Rhode Island and New England electricity ratepayers for having nothing. How does this work? How did that happen? And by the way, 2 weeks ago, the ISO, the entity that runs the New England electricity grid, made a filing with its regulator, the Federal Energy Regulatory Commission in Washington, D.C., to change the ISO rules to make sure this never, ever, ever, ever happens again. So this is how it happened. You remember back in February 3rd, 2016, the ISO ran this so-called forward capacity auction. This is a once-a-year event at which multiple energy producers compete in an auction for getting an arrangement, a deal, essentially a contract with the ISO to be available to sell electricity in the future. If you win in this auction, you're not selling electricity, you're merely agreeing to be available to produce electricity 3.5 years in the future if you get called on, if you are needed. And the deal is, in exchange for your agreement to have a power plant, to build a plant, and to be available to produce electricity, the ISO gives you money because they're getting something valuable for it. If they want you to produce electricity, you'll be available to produce electricity. So on February 3rd, 2016, Invenergy got this capacity supply obligation, a legal obligation, to begin producing 485 megawatts of electricity starting June 1st, 2019, 3.5 years in the future. Well, when June 1st, 2019 came around, they didn't have a power plant. They weren't able to produce electricity. And this is an event that has been foreseen. It's not unheard of. And so there is an annual opportunity for companies that have these capacity supply obligations to trade in or out of them. And what this meant was 2 years ago, we could see Invenergy wouldn't have a power plant on June 1st, 2019. So they sold that obligation to another energy producer who bought it. The law of supply and demand came into play here. And because there was far, far more electricity than was needed, Invenergy Invenergy had to pay this other producer less money to take on its obligation than they were getting from the ISO. Is that so far clear? So Invenergy goes to another producer and says, listen, guys, we're not going to be ready June 1st, 2019. Will you take our obligation for us? Guy said, yeah, they'll do it. Invenergy still gets this much money from the ISO, but pays this much money to somebody else to take over the obligation because there's a glut of electricity on the market. First time Invenergy did that, they made $7.9 million for 1 year, 2019 to 2020. Then they had to do it a second time because they still weren't ready. Second time they made $20 million. So between those 2 years, Invenergy made $27.9 million. And I can tell you, because I've been sitting through the ISO meetings where we've been discussing changing the rules, changing the ISO tariff, so that can never, ever, ever happen again. Think about the people who were really, really pissed off that this was happening. Every state in New England, by law, has a statutory ratepayer advocate who looks after the interests of ratepayers. Here in Rhode Island, we call that the Division of Public Utilities and Carriers. It's different from the Public Utilities Commission. In Connecticut, it's the Office of Consumer Counsel. In Maine, it's the Office of Public Advocate. In Massachusetts, it's the Attorney General. It's Maura Healey now. But every state, by law, has a statutory ratepayer advocate who looks after ratepayer interests. Well, all of them were furious at Invenergy because Invenergy was making $27.9 million off of ratepayers. You know who paid for that? You did, you did, you did, you did. That money went to Invenergy, and you didn't get anything for it. Who else was angry? The ISO was angry. Why? The ISO by law is required to make sure that our electricity grid is safe and reliable. That when we flick the switch, the lights go on. The ISO had 1,000 megawatts of Invenergy's phantom power in their system that wasn't working to keep the system reliable. That made the job of the ISO much, 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 much harder to do. And they're legally required to keep the grid safe and reliable for all of us. And their job got harder. Who else was angry? Every other fossil fuel producer in New England was angry. Because in these annual capacity auctions that the ISO runs the first Monday of every February, the amount of money that the other fossil fuel companies get, other fossil fuel power plants get, is a result of supply and demand. Prices were low, low, low because Invenergy was glutting the market with phantom power. It wasn't real. They were getting less money because of Invenergy. My experience is usually fossil fuel companies and fossil fuel power plants stick together. When CLF litigates against the fossil fuel power plants at the Federal Energy Regulatory Commission, on the other side of our lawsuits are the New England Power Generators Association, NEPCA. It's all the fossil fuel power plants sticking together against us. Here, all the fossil fuel power plants were furious with Invenergy because their markets were getting screwed up by Invenergy's shenanigans. And so the ISO has just filed papers at FERC in Washington to make sure that nobody can ever, ever, ever pull that stunt again. And Invenergy, I think, well, you remember the last sentence of CLF's brief. We said, to the EFSB, we said, Invenergy is in the unenviable position of being the only so-called, quote, power plant, unquote, in history, in the history of the world, to have cost New England ratepayers tens of millions of dollars without ever producing one electron of electricity, without having a power plant, without having a permit to build a power plant. The ISO just changed the rules to make sure that that will never happen again. And there's a very, very good explanation of that on the Uprise RI website where we go through that. And Steve explains how, although the FERC filing, which I think he links to, doesn't specifically mention Invenergy, it's very, very clear that this is what everybody is talking about. People were not pleased with that.
And we're glad for it.
Other questions? Thank you very much for joining us. Have a piece of cake on your way out, and join us at the State House when we get some climate legislation passed this year.